So this session is about the sentence recommendation. So this morning we talked about offense gravity score and thoughts about how to assign that. And then Matt just talked about prior record score and thinking about criminal history. And so, the next step is adding the two together and you come up with this recommendation. So we just wanted to sort of have this as an open-ended discussion about some of the issues that relate to this new approach to sentence recommendations. And so one of the handouts you have is the revised matrix. And again, the color's different, so you got that. A lot more OGS categories and fewer prior record score categories. And really some sort of mechanical things that are in place in terms of step up, step down that we can talk a little bit more about. But I guess the starting point in the recommendations was something that Judge Marsico and I were just discussing, and that is when you're trying to combine all these things together, add more offense gravity scores, reduce prior record score, have more targeted recommendations about both disposition and duration, what you end up with is really tight ranges. And some of these ranges are just, a couple of months. And even if you add in the aggravated and mitigated, you're still talking, a range of maybe 6 months. Now, in a relative sense, when you're talking about misdemeanor ones and you have 1 year to work with and a 6-month statutory limit, that's still a pretty wide range. It's covering a big chunk of what's available. But there are areas where trying to sort of figure out how you balance all these things or bring them together was difficult, because if you start to widen the ranges, then they either overlap or you have to reduce the number of offense gravity scores. And what we really wanted to do, at least through the strategic planning group and forward, was really come up with these guidelines where at the 0 prior record score, there is a real focus on first a sole disposition that you're recommending. And then as you move across the prior record score, you're generally picking up time, you're adding duration instead of switching from, let's say, probation to confinement. In level, well, I'm going to say level 2, but I guess it's level B now for probation. If you look across, as an example, if you're looking at your chart at, let's say, OGS 4, the initial recommendation, 0 prior record score, is 6 months of probation. And again, we wanted to give some visibility to the recommendations about community service as a sanction to be used in lieu of fines or as a sole sanction. And so those numbers are listed there. But if you move across the low prior record score category, is then an increase from 6 months probation to 12 months probation. So you're retaining the same disposition and you're increasing the duration. When you move from low to medium, you retain the same duration, 12 months, but you add in a restrictive condition of probation for 1 month. And all along, you're increasing the community service hours or the fines. But the idea there is that in our revised enabling legislation, where it talks about probation and probation with restrictive conditions, it talks about the commission making recommendations that talk about the duration of probation and the intensity of probation. And the intensity is the use of those restrictive conditions. And so what the committee had discussed was, let's try to hold fast, if we can, to the disposition. So if you're at probation at the start, let's see if we can retain probation, but the enhancement because of a prior criminal record would be either an increased duration of the probation or some intensity. And so you can see when you get out to the high category, prior record score category, you've gone from 6 months at the 0 up to 18 months of probation at the high, and you've added 1 to 2 months of restrictive conditions. Now at OGS 4, these are going to be really minor offenses. These are going to be misdemeanor 3 offenses. But that sequencing, that sort of process that we put in place, we tried to honor as we were moving up through the guidelines. So you'll see that there's a real effort to try to, as you're moving across on the prior record score, there's a real effort to try to retain the same sentencing alternative and increase the duration or the intensity. When you get to OGS 9, I think you see where we know we have to do a crossover. That, you know, at some point you're going to be moving from one disposition to another. And so at OGS 9, prior record score 0, you're starting at sort of the top limit of probation, because as a probation, as a standalone recommendation, the highest we go is 36 months on these guidelines. And so the next step from there would be to move to confinement. And so you'll see that you move over into the next level of the guidelines with the low prior record score. And you'll see it's just 1 to 3 months of probation, of confinement as a minimum term. But the RC below it gets to what we have in the current guidelines, which is the trade-off, that there's a provision that you can trade off any of those county confinements for eligible offenders with the use of restrictive conditions of probation. And the idea there, and that we have under the guidelines, is probation in that area could be up to 5 years. And the restrictive condition there is recommended of 1 to 3 months if you're going to use that in lieu of incarceration. So that's the idea. And then if you continue to move across in the prior record score, you'll see you move from 1 to 3 months to 2 to 4 months to 3 to 5 months. So it's pretty slow. But again, these are mainly probably misdemeanor 2s in this area when we do the reassignments. And so you don't have a lot of bandwidth to start with. So the recommendations are going to be sort of low and slow in terms of increases. As you move further up in that green band, you'll see when you get up to 18, you have that sort of border cell where it's the longest county jail sentence based on the minimum sentence recommendation. So we're recommending 9 to less than 12 months, and that could be replaced with restrictive conditions of probation, and the probation for that could be up to 5 years. And then that's where, when you move to low, you're moving over to another sentencing alternative, in effect, state prison, because the minimum sentence now is 12 to 18 months, and then so on as you keep moving across. So that's just at least the reasoning as we were trying to think about this progression across the guidelines based on prior record score. We tried to the degree possible to stick to the same sentencing alternative, and then just work on increasing intensity or duration. Well, let me just stop there and see if there's just any questions about that kind of approach. Again, not necessarily agreeing with it, but just any questions about how we have that. Yeah.
I have a question, and it's really more for the members of the bench here on the commission. I'm curious because you're right, the bandwidth is so much tighter. When you have defendants plead open in your courtrooms, I mean, what are your thoughts on this? You feel that it's restricting your ability to take into consideration every factor, or do you like it?
Mark and I had a discussion, at the break. I said, the irony here is that there's been such a move with against mandatories to give judges more discretion. But here, this is sort of the flip side. I think you're really limiting the judge's discretion. Back to Matt's example this morning, the burglary, not in a home, no person present. That was RS to 9 before, where he plugged it in today. It's now 4 to 6. A default. I've had a bunch of those that are like concession stands at a pool. Or we've given kids not kids, they're 18, but giving people ARD even for stuff like that. now to get to probation is a hurdle, in a case like that. So, I mean, there's things I like about it, but though it's tight. Yes.
Yeah, and we recognize that. And like I said, some of this is just sort of the structure. And let me just use like that as an example, because I think it does make the point. Let's look at C, the sort of dark green section. So you'll see that it's 10 to 18. So you have a whole bunch of sort of maneuverability within there. So take an assignment of 14 or 15, somewhere in the middle, and think about a negotiated plea or the court identifying factors that are present that maybe results in a number of factors in play. It's an inchoate, so there's a drop of 1 or 2. It's there's substantial assistance that the DA agrees to, and there's 1 or 2 drop. But there's also serious bodily injury, or there's I don't know. You can just think about a lot of things that that you're in effect checking the box in the application, and it's adjusting the OGS to figure that out. Well, you need some ability to move up and down, because it might just move in one direction, right? And you want to make sure that you're capturing the accountability or whatever it is that goes with that new factor being in place. So we wanted to make sure there was enough space to sort of move that way based on the factors to do those kind of adjustments. And then taking into account aggravated and mitigated, so you use the sort of cell above and cell below, sometimes 2 cells, to sort of talk about what that range is. And even looking at all of that, I agree with your point. They're really narrow ranges, especially compared to what we have now. But the question is, how would you construct this to have a lot of steps, to have that variability in that step stuff without either overlapping in a really big way or involving multiple sentencing options? Because that was the thing we were trying to get away from. We were trying to have like specific sentencing alternatives, like probation versus jail. And if you start overlapping it, let's say at 10, you, instead of 1 to 3, you did 1 to 5, 1 to 6, something like that. And then you just keep doing that same kind of distance heading up. You get to 14 or 15, and you're going to be at your less than 12 months. So all of a sudden, you've eliminated 2 or 3 steps because you don't have that. So the question, I guess I'd throw back, because I think you're raising a really good issue, is there something else that can be built into this to give the court greater flexibility? Like, for instance, when we talk about aggravated and mitigated in the lower cells, you like step up 2 steps instead of 1 step because the ranges are smaller. But as you get up, it's a 1 step, or if you're moving over a category, 1 step. So I'm just wondering if there's ways that we could use this approach, retain the multiple steps, but give courts that broader range that you're talking about. So, we don't have to answer it today, but that's what we're looking for.
And I appreciate that. And I agree with you that is the difficulty. So part one to this is, clearly judges have the ability to deviate from the guidelines should they seem appropriate. Right. So there's that. And that's obviously something that judges, I'm sure, would utilize under the right circumstances. The one thing I really like about it is, I think about a county like York County, where we have close to 8,000 adult criminal cases a year. And the reality is, when you have assistant district attorneys making offers in cases, they have there's a lot of latitude there. Yeah. And one of the things that I see with this is a way to really sort of harmonize across the state offers that are made in cases. Obviously there's always exceptions to that, but it just seems to me like this would provide a little more control on how offers are made, and not that those offers will result, like that will dictate the end result, but it does dictate progress and pace of the case. And so I think that that's a definite bonus or a benefit to a structure like this.
Yeah, and we heard that, and this goes back to the strategic planning work group, and I think it was the prosecutors that were involved in that were talking about wanting to have confidence in negotiated pleas. Because, as you know, around the Commonwealth, depending on the county, sometimes negotiations are just to the charge, and sometimes it's sentence, and sometimes it's. And in those cases where there's a negotiation to a sentence or to a range, that was, I think, the biggest concern, that you had these wide ranges that you didn't know what you were going to get because you negotiated to a range, but the judge could impose probation or state prison.
And right. And the other issue is, like, when we think about procedural justice, and I know we all understand that when people understand why things happen, there's a greater likelihood of them accepting the outcome, even if they disagree with it.
Right.
And when I see a structure like this, I mean, it really provides more of a window into why the end result occurred, versus there's this huge spectrum, and someone in courtroom A went to state prison and someone in courtroom B got probation. And that happens.
Yeah. I think, one of the things we can look at and go back and work on is, are there ways to broaden the ranges and still sort of retain this step process? And I'm not talking huge expansion, but, by a couple of months, I think just to try to see something. One of the difficulties we had was on aggravated and mitigated, the sort of stepping over ranges, because at the lower level where you have that 2-step increase, and then you get to the next range, which is 1-step increase. And it's just sort of inconsistent how that works. And we were trying to see if there was a more consistent way. So maybe there's, something we could do in terms of those border ones that maybe we violate our rule in terms of having 2 options available instead of 1, or something like that, just to get through the transition. There's other states with guidelines, they call them border cells, where they have sort of it's presumptively prison, but it allows for jail, something like that. And maybe we can look at hybrids on the borders that then allow us for each of the cells to increase by.
So I like the narrow ranges. Well, because it does strike me. I mean, right now our ranges are so broad. To say somebody gave a standard range sentence doesn't mean much. I feel like with, like, even the example that we were just talking about, that level that offense gravity score 13, if you're including the aggravated and mitigated, you still have the range from 3 to 7. And I mean, we're dealing with smaller numbers here. So it's not, I guess, if before where it was RS to 9, now you have 3 to 7 when you're including, that. I just feel like now from an understanding of the sentences that are being applied across the state, it would help us dramatically. To say that we have 90-some% compliance is really doesn't tell us much when the ranges are so broad. I mean, this would help, I think, us to indicate, to get a better understanding of what's going on in different counties. And when you can move up a level or down a level and still be within that aggravated or mitigated range, I feel like it still provides some flexibility, but it'll help us in terms of data collection so that we can better understand what's going on, and just sort of narrow the field for the practitioners out there.
And I think also that, inconsistency of outcomes is one of the largest drivers of perceived inequalities in the system. And I think the more we can have consistent outcomes, I think it benefits just the entire criminal justice system. And so I think this is a great start. And I also wanted to say real quick, in a positive light, you guys put a lot of work into this, and I'm tremendously appreciative. It's clear that so much thought and time and data and just thoughtfulness was put into this. So thank you.
Appreciate that. Just 2 quick notes. One on procedural justice. I think you're absolutely right that at least one of the intents here is to be more transparent and to, in effect, document common reasons for sentences. And I think that's clear to the defendant, and it's clear to the public. And I think it puts sort of on the record, what the basis of a negotiated plea is. I mean, if you look at our annual report where we talk about, reasons for aggravation or mitigation, usually one of the highest ones is negotiated plea, which tells us absolutely nothing about like, should we be changing the guidelines? Is there a factor we should be looking at? So this at least tries to document factors that are important and get that down. And what that helps, it not only helps in the case, but the other thing is we're a legislative agency. We get calls all the time about, the impact of this bill. And the more solid, detailed data you have, the more you can provide good answers to the General Assembly as they're considering legislation. So I think it's helpful, to strike that balance to try to, get whatever information we have and make it available. So anyhow, we'll take a look at this to see if there's anything we can suggest. Like I said, there's a couple like awkward areas in terms of aggravated and mitigated, other things like that we were trying to figure workarounds, and we'll just take a look at this and see if there's any adjustments recommend. Yes, Judge.
I will say that when Judge Marsko spoke, I felt pretty much the same way.
Yeah.
However, listening to the other commission members, and also Bernstein indicating that there's a variation just within your own courthouse.
Yeah.
That narrowing probably do make.
Thanks, Judge. Any other thoughts on just that issue? So then the next issue is concurrent consecutive sentencing. I'm sorry, I forgot. There's one thing I was supposed to talk about with prior record score. Under our current guidelines and for guidelines since 1997, the way we determine sentence recommendations is for every offense, we consider the OGS and the prior record score. And the combination of those is used for every sentence recommendation. So think of it as just individual offense sentences. But prior to 1997, our guidelines were viewed more as a criminal incident or a proceeding or something like that, where the prior record score was calculated, but it was only attached to the most serious offense of the incident or of the proceeding or the transaction, whatever word you want to use for that. And so on that lead offense, the full impact of the prior record score was there. But on any lesser offense in that criminal incident, it was a 0 prior record score. The idea was we're going to address criminal history one time and it will be on the lead offense. And for the rest of the offenses, we're not going to like double count. We're just going to have it there. The reason the commission made the switch was we were moving to more of an offense related approach, but also there was this whole issue around concurrent consecutive sentences. And the idea was just as practices vary in courtrooms and by prosecutors and judges statewide, the same applies, many times over with law enforcement. You have way different policies about who's charging. Does the DA get to approve the charges, things like that? So, in some counties, you'll have law enforcement charging anything that potentially can stick, I guess, and it is filed with the MDJ. There's preliminary arraignments. It's part of the process that's moving through the system. And in other counties, there's like a pre-filter. Either the DA has to approve the charges, or there's a local practice of just like focusing on lead offenses or things like that. But there's varying practices county to county and from sometimes law enforcement agency to law enforcement agency. And it's not that one's right or wrong, but it's that it's inconsistent. And up until 1997, there was a rule that assumed that sentences were concurrent unless the court stated otherwise. That rule was removed about the same time we changed our policy about prior record score. And so when we talk about the impact of the prior record score, we've contributed to that because of this like double hit that happened in 1997. We started applying the prior record score to every offense, sort of assuming that concurrent sentencing would just sort of continue to think in these things in terms of sort of sentences within an incident and concurrent sentences. But that rule was removed and there was an increase in the use of consecutive sentences. And so the prior record score now becomes just a more visible and meaningful part of sentences, and the aggregate sentences increased as a result. So, I mean, not in every case, but the thing is, if we're talking about promoting uniformity and proportionality and consistency, we moved farther away from that because of these things that happened in 1997. So the only reason I raise that is we're still dealing with the same kind of issues. And if we're doing a rebuild of the guidelines, at least one thing to discuss is how does the prior record score apply? We just spent a lot of time talking about how you build it and if it applies, how much weight it has. But the question is, should it apply to every offense, or do we go back to a policy of thinking of applying it just to the lead offense of an incident, that the penalty, the enhancement we give for prior record score attaches to lead offense? And one of the reasonings for doing that initially was that, generally speaking, sentences within a criminal incident in the past were imposed concurrently, and across incidences were imposed consecutively. And the exception to that was when there were multiple victims, that you'd see consecutive sentences within an incident. Now, it's not a perfect rule because it's not a rule. It's just sort of practice, but that is what we generally found. And so prior record score increased because you sort of got rid of that framework that we had and you allowed it to be part of the mix more often. So anytime there was a consecutive sentencing, you had this like additional hit or sentence within an incident. So anyhow, I just raise it as an issue for the commission to think about. And, as we move forward, if there's interest in moving to more of a criminal incident approach, then one of the considerations would be whether prior record score should only apply to the lead offense, not to the lesser offenses.
Can I just ask an example? Sorry.
Yeah.
So if we had, say, a rape or an IDSI, and along in that same incident, you had a corruption. So we would, when sentencing, we'd look at the guidelines on the rape, including a prior record score. But then when we go to sentence, we'd go to the 0 on.
That's correct. Yep.
Other,
that's correct.
Okay, thank you.
And that, depending on the nature of that offense, and assuming there was one victim, but depending on, there might have been multiple harms, multiple incidents happening within the incident, right? And so, or multiple acts. Whereas, there's also incidences like, burglary, theft, criminal conspiracy, PIC, like a whole group of things that happen. And really, it's all about the burglary, right? But in some jurisdictions, all of this other stuff will be charged, and then prior record score is applied to all of that. And then if there's consecutive sentencing, if it's sort of inconsistent, you can have a much longer sentence because not only is the prior record score applied to it, and its aggregate sentence becomes quite a bit different. And again, it's not even about whether that's a good sentence or bad sentence. It's just inconsistent. Like there's not a rule. And so anyhow, just wanted to put that on the table. The reason we raise it as part of the sentence recommendation is that when we're thinking about prior record score, what offenses count. Matt was talking about sort of this categorical approach. Just look at every conviction. Look at every conviction that's on the record in this person's prior, all convictions prior to the commission of this offense. Identify the most serious offense. And if there's multiples of them, determine if it was multiple dates or multiple victims. Because the categories are, what's the most serious offense and how many were there? And the how many were there gets to, were there multiple victims, single victim, multiple incidents, single. So you can see how we could automate this too, because we're just saying any convictions prior to the commission of this offense, identify them all, identify the top one if there's multiples, any, and that way you can plug it into category. So you could see how that kind of approach could also help to inform how we think about prior, whether we apply to the lead offense or all.
Mark, doesn't that complicate automation though significantly?
Actually, it makes it simpler because right now we're really focused on all of the incidences, the OTNs, all the other kind of stuff to sort of get a rap sheet and find everything. Plus, we're looking out of state and trying to figure out what's the current equivalent offense, and then we're trying to fit it into the 4 or 5 categories: 4-point offense, 3-point offense, all of that. This approach, all we do is just say, tell us all the convictions, every conviction on the record. We don't care if it's concurrent, consecutive. We don't care about anything. Find the most serious one. If there's more than one if there's only one of those, we're done. That serious offense, and that tells you which category you're in, based on how serious it is. If there's multiples of that offense, then what we're wondering is, was that in one incident or was it in many incidents? And was there one victim many? Because either of those were treated as multiples. And if they were all in the same incident, be considered a single. And that's just to automate the prior records. Now, if the court has a PSI, has a rap sheet, has details and says, yeah, but this underestimates the seriousness of the offense, or there might have been multiple victims, or this might have been 5 occasions, not 2 occasions. That's certainly a basis for aggravating or departing above the guidelines. It's just coming up with a simple category of prior records. So anyhow, that was the second issue, I guess, the concurrent consecutive, and just trying to think about whether prior record score applies to all offenses, lead offense. The third thing is more a policy issue for the commission, and it gets to the sentencing information. So the risk assessment is in place. We continue to see that as an important part of this whole process moving forward. Risk assessment is calculated and determined prior to sentencing, and there's information provided on the guideline form about whether additional information is suggested, and that's for the outlier high risk. And we've been really promoting the development of risk needs assessments as part of a PSI and making that kind of information available to the court prior to sentencing. So that's our policy that we have about risk assessment. When we met with the with the academic review panel, one of the days we had some staff from the Sexual Offender Assessment Board meet with us and to just talk about sex offenders and things we should think about relative to guidelines, sexually violent predators, all that. And one of the things that they mentioned was that they see a lot of inconsistency from county to county in whether the court receives the SOAB. Because, by statute, it's provided to the DA, and the DA decides whether to move forward. And in some counties, the procedure is that when you provide it to the DA, you provide it to the court. But there's other counties where the court doesn't get it unless the DA moves on having the hearing for it. And so just as, as trying to promote the court having information on the case, we think those SOAB reports are great, have a lot of useful information. And if nothing else, it just seems that the commission, if it's supportive of it, could recommend to the General Assembly that provision of Title 42 be amended to request or require that the report also be sent to the court. I mean, it's like no harm, no foul. And it seems to me it's really useful information that the court should have sentencing. And it's not about punishment or anything like that. It's just about, a really solid PSI that deals with. So that's just sort of a recommendation, but it's consistent with just our view that, in any way that we can improve the quality of information going to the court, we should think about that. So, so in that vein, another, I guess, opportunity for the commission to think about is whether it would be helpful or appropriate to contact the Criminal Procedural Rules Committee to just talk about PSIs. The rules supersede statute as far as PSIs, right? So the statute's been invalidated and rules apply about how they're prepared and what's in them. And that rule, was a good rule when it was adopted, but that was, many years ago. And I think, there are some really good PSIs out there and really well-prepared PSIs. And the National Center for State Courts has done a lot of work on best practices PSI. And I think there'd be a lot of value in the Rules Committee taking another look at PSIs about what's included in them, when are they provided. I mean, in a perfect world, when we're recommending a PSI as part of the risk assessment, that the rules would encourage the court to consider that or something like that. I just think there's a lot of value in coordinating those efforts. So those were sort of two recommendations from the academic review panel, one in terms of legislation, one in terms of, so a couple more things, but I guess I'll pause to see if there's any comments or questions. So the next is problem-solving courts, and I mentioned this, I guess, during the last session that we have nothing in the guidelines that really talks about recommendations for problem-solving courts. I think in Amendment 6, for the first time, we even mentioned problem-solving courts as like one factor that could be identified as a aggravating or mitigating circumstance. But especially in those cases where problem-solving courts are being used, and I know they're inconsistent from county to county, it just seems that it might be something worth thinking about how it fits into the guidelines. So we know that there's problem-solving courts that are pretrial diversion, and there's some that are reentry, but we're really focused on those that are used at sentencing. So whether the aspect of the court is that you're in effect placed on probation, something like that, that's sort of the focus of where the guidelines would come into play. One thing the commission did a number of years ago was we worked with the Administrative Office of the Courts on the accreditation program. So we contacted the AOPC and talked about contacts we had from problem-solving court judges that were concerned about that their dockets for problem-solving courts were blended with their dockets for sitting criminal court. And so when they received information about their sentences, they'd see these departure sentences because they were accepting someone in the problem-solving court. But that afternoon they're sitting a homicide case or whatever, and it looks like they're to the public it looks like they're departing below the guidelines and murder or something like that. So what we had agreed to do was work with the AOPC on this accreditation, and AOPC got in place accreditation for drug and DUI courts. And what we said at the time is if you're an accredited problem-solving court, the commission at your request will in effect adopt 2 dockets for you. So all of the reporting of cases, if they're tracked by you in terms of problem-solving versus otherwise, we'll establish like 2 profiles so that you can have both of those and they're sort of separated. And we'll do any other things we can to try to support the problem-solving court in that county. Not much has come of that, but if we're thinking about problem-solving courts, one of the things is, are there other areas of accreditation that are or should be considered? Mental health courts, veterans courts, things like that. And is there anything else the commission should do in terms of building those or considering those guidelines? So I'm not sure there's anything there, but those are things that we talked about, especially during the strategic planning work. We already talked about youthful offenders, just that 18 to 25 and anything that we can do. And then the final issue I have is just sort of wide open on options and resources. Judge Bernstein and I talked about this along with Judge Tucker last week. But just the idea that even if you come up with great guidelines, it's really driven by the resource at the county level. What kind of programs are available, what kind of funding for those programs. And so, I just wanted to close by, I guess, mentioning, the recognition that we can have great guidelines, but trying to find opportunities to sort of partner with counties and promote resource alternatives to worth considering. Judge. Well, I think we've been working on it a lot, but I know this is like a fire hose today with all the information, and we're hoping that as we conclude this, that we can get some sense of sort of the direction we should be going in terms of what staff can do to move this along. It would be great if we could come back at the September meeting to provide you with a revised draft and greater detail that we can start working on with the policy meeting and the commission meeting. I would hope that that we'd be in a position, maybe by the end of the year, but certainly by early next year, to try to have something that we could at least take out for public comment. And it's a big change. So I think the sooner that the commission, identifies what's worth considering or what's viable, and get it out for public comment, we can have meetings with judges and prosecutors and defense attorneys and probation and try to figure out what are the strengths and weaknesses of it. The other thing that I think we did with the parole guidelines, at least when we put those out for public hearings, we had hearings, remotely with some of the SCIs, and I think that was just, it was certainly a different, a different focus, a different opinion from people that were really impacted from this. And we talked and have since then in public hearings, tried to look for opportunities to meet in other locations, go out to communities and meet with them for public hearings. We've had some discussions with Lincoln University about some locations, or a location they have in Philly that they might be willing to host public hearings. So I think there's just, I think especially with how substantial these changes could be, the sooner we can get something out to the public, the better we can move forward. But I would hope in the next year or two.
Mark, is there anything that commission individually or collectively can do on?
I think from our point of view, and we'll bring this to sort of a close now. I think I think the most important thing is some of the earlier discussions we had about the offense gravities. Like I said, there's a couple thousand offenses that we need to figure out a way to manage that, to get stuff before you that you can, you have an opportunity to sort of think about what's appropriate and make changes. And that's tough to manage. So I think, if there's support generally for, taking data on median sentences and using that to like initially plot the OGS, and if there'd be some consensus around like the rule, like do we always go with the highest one or always the lowest one or find the middle, something like that would help us to identify that. And, you know, if there's, you know, no data, or if there's, you know, really limited data, or it's just all over the place, it's meaningless, that, you know, maybe we can work on establishing some protocols for grouping of offenses, you know, about, oh, these are violent offenses, or these are drug offenses, or these involve bodily injury, so that you have groups that you can look at and say, well, collectively, yeah, these look like jail sentences primarily, and we can work from that. But I think we need something, some kind of direction to get a sense that you're on board, that this generally is worth pursuing, and that we can package something and bring it back. Yeah.
One of the things that, as you were going through the offense gravity scores, struck me is I feel like over the years, we as a legislature have mandated different enhancements and added different statutory provisions. Are we gonna, I assume that you are keeping those in mind and either going to provide the members of the legislature with a list of items that need to be tweaked or repealed or changed if we sort of make a wholesale change about the way our guidelines are working? Or are you working within those constraints as you rebuild this?
Yeah, right now we're working within those constraints, but what we try to do, and what we can do in terms of you know, providing a summary or something, is for where we see gaps, maybe we can identify those, because maybe that's legislative action, or maybe that's the intent of the General Assembly. But you know, there are plenty of cases where you see second or subsequent offense being a change in the grading, and then there's plenty of others where it's not. And then sometimes the commission makes that an enhancement to the guidelines or a sentencing factor for subcategorization, and sometimes we don't. So we could try to look for those things, for like inconsistencies, and then, you know, you all can review it, and to the degree that you think there needs to be a fix legislatively, you know, we can give a menu to the General Assembly, and otherwise we can work within the current framework.
Yeah, I wasn't looking for more work for the.
Well,
no,
but that would help with the consistency.
well, agreed. But I don't know if it all has to come from the General Assembly. I mean, I just want to make sure that we weren't, and I'm certain you are too, you've been doing this a long time, weren't going to find ourselves, you know, inconsistent with a statute that has been passed somewhere along the way that says there needs to be an enhancement for a certain type of offense. And then we go ahead and, because of what the changes we're making, we're no longer providing that enhancement.
Right.
That
No,
was my
I
bigger
think,
concern.
yeah, I think we're good there, but we'll keep an eye, especially with the enhancements, because we do have a lot of them, and some of them are a little bit complicated. So
I like the idea, if there's a way to collapse them or incorporate them into the regular guidelines so that you're not, you know, moving,
back and forth.
yeah, going on. Well, which matrix am I using? Am I using
That's
this matrix?
exactly-
That matrix? I mean,
yeah, that I mean, that we've heard that repeatedly, and I think that's a guiding principle for us
Okay.
to simplify it that way. Let me mention one gap thing that we didn't talk about today, but it's been difficult for the commission forever, and it's murder 3, the sentence recommendations for murder 3. You know, right now it's an OGS 14, and it's, you know, talk about wide ranges. You know, we start at I think it's 72 months and go up to the statutory limit, so 20 years, right? So and then you have a 12-month aggravated and mitigated. So we have basically 5 years to 20 years as a minimum sentence range for 0 prior records for murder 3. And we have talked about this on a number of occasions, about how difficult it is to come up with subcategorizations or other kind of ways of thinking about murder 3 to narrow the range. And it's really difficult because, and I talked to our Duquesne professors about this. It's difficult because, you know, sometimes you have a murder 3 that, you know, was effectively a murder 1, and there was, you know, maybe there wasn't proof of premeditation or whatever else, but or there's negotiated plea to avoid a jury trial to murder three. You have murder threes that are, that end up there because voluntary manslaughter might have been the other option, but it was not on the table because it was being used as a defense basically. So you have those kind of like extreme things where it could have been higher or it could have been lower, and it ends up at murder three. And then you have all kinds of stuff about murder three. We have effectively postpartum depression murders, and you have abuse of kids, and then you have domestic violence. I mean, it's just we put together a package of 10 or 12 cases from the Villanova sentencing workshop, and they're just all over the map. And so the question is there anything that could be done with murder three to have a more reasonable, appropriate sentence recommendation for a zero prior record score? And so it's not anything to like decide now, but it's just one of those things where that OGS 14 category for murder three is so wide because the commission over the years has said it's like it captures everything. So we're just gonna set a floor, and we're gonna let the ceiling be the statutory limit. The problem is we then put other offenses in that category. So rape and IDSI, victim less than 13 is in that category. Eco-terrorism, I think, or some of those things are in that category. So there's a lot of other stuff that then ends up there. So it's bad enough under the current guidelines, but then when we try to think about how to plug that into the proposed guidelines, it gets particularly difficult. So I wanted to plant that idea because as we're thinking about inconsistencies or gaps or other things like that we can try to track, I think that's at the top of the list of just any thoughts you all have about how to recommend appropriate sentences.
Oh, go ahead.
Just real quick, I think also we should take a look at drug delivery resulting in death. And I don't know off the top of my head what the guideline range is for if someone has zero prior record scores. Do you know what it is by chance?
I think it's a 13 because I think it was 14 when it was considered murder three.
Okay.
When they moved it down to a basically a felony one, I think it went to a 13, but I'd have to.
Okay, because I know, I hear from a lot of my colleagues across the state more and more that people are investigating and trying to prosecute this crime. I know in York County, we have, if you look at our sentencing ranges for that crime, it's everything from what was state IP, through pretty high sentences.
Right.
And so I see that as an area that's going to more and more become a place where you're going to have a disparity in sentencing. So I just wanted to kind of put that out there.
No, I appreciate that. I think you're
It's
absolutely right.
It's a
And
13.
It's a 13?
Yeah,
Okay.
13. And it's an F1. I'm not sure if that statutory max 20 years or 40 years. Not
I can look in statute. It's a felony one.
Yeah,
I'll look.
Can
I think
I
it's 40.
40.
Mhm.
just suggest, since there's going to be outlier offenses that we can
Yes.
address, but I think what you're looking for is a thumbs up for us to say between now and our meeting in September, are we okay and on board with the staff looking at for the OGS, this step up approach with what do we have, 40 cells? Am I correct? Or levels?
41, I think.
Okay, but,
35
and then
plus.
looking at places, all the offenses where they can look and get a median and get that as a basis and assignment, set aside those and maybe highlight those outliers like the drug delivery, the murder three, for further discussion. And then those where we don't have sufficient numbers for the median really to make place, to come back to us with groupings of what those look like prescriptively to put them in some category. That's what you're asking for.
That's
Is there
exactly it.
anybody who is opposed to or has better suggestions than what's been brought up? So I think that we'll give you the go ahead to do that and to
That's
provide
great.
this. And is there anybody that has a strong objection or any objection to the commission going forward with the 4 levels of a prior record score as opposed to the 8, 7 we have now. Is everybody understanding and okay with that for now? I mean, I understand we can shift. I know we're going to look at some numbers, but I think when we have things plugged in, it's going to look less esoteric and more practical so that we can have a foundation of where to go from there. And then my last question is, with all these adjustments, the ups, downs, I'm just trying to think as a practitioner. So I'm going to be able to open up and see my wonderful new matrix, and I'm going to be able to look at the guideline ranges. But is there going to be something easy for me to look to see what my adjustments are, where I'm not flipping a gazillion pages for the ups, downs? Is that going to be something?
Well, I'm going to say yes, because I'm going to depend on Christie to make all this magic happen at some point. But here's, I think there's a 2-step approach. I think one is, we clearly have to have a list of adjustments. So, part of this is the commission doing the initial assignment and any kind of subcategorization, that kind of stuff. And then separately is, what are the things that we have available, a menu of, 10 or 15 things that are step up, step down. And you could see that as, on a paper form, a checkoff list. Here's the conviction offense. Which of these apply in this case? Deadly weapon, enhancement, whatever else. And then, it's plus minus whatever else. And you could on paper determine what the OGS, the final adjusted OGS is. But you can imagine an application doing that and capturing that information. And so that's the plan, to rebuild the application consistently.
So I think everybody's in agreement to go ahead and present that to us.
On the OGS, when we go through for the median for the assignment, Matt discussed cases where there's a single option, and that's easy for us. But there might be cases where there's 3 or 4 ranges, cells that capture the median. And as we found this morning, in some cases we went to the lowest one, sometimes the highest one, sometimes what looked like the middle. It was like Goldilocks. And so, is there a preference? Should we sort of shoot for the middle if there's multiple options? Is there any kind of default that you're comfortable with?
I was thinking my input would be the like the example we had today with the burglary, there was really only one that spoke to the numbers, even though we had a median that where we were at the 18 for the burglary, homes, home present. If we went above or below, it really didn't capture the median appropriately, I think, for where you'd want to step up or step down. So can you look at the median, but can you also look where the next biggest, because if the median's here, but the next biggest percentile was this direction, more severe, maybe start with the middle of, if it falls into more than one, I'd say look to where the left and the right of the median to see, because I thought there were certain times where it was very clear that if you weren't at the median, everything, we were still looking at lower than, more than higher than. So I think look to where it falls, and if there's 3, go in the middle, start from there. If there's 2, but that would be my suggestion, to lean, where is it going after you look at the median?
I think we're on board with leaning. That sounds good. I think there are going to be times where it's just, it's one or the other. And if there's a default, trying to, the discussion with Representative Stevens this morning, I thought was really helpful, because these numbers build in all the negotiations going on right now. And I think it makes a case for saying the midpoint is sort of fair, because it's taking those into account. And then if we then have this adjustment, you're going to deduct that and you get back to sort of where you'd expect to be, because it's part of that data pool that you're looking at. Whereas if you start at the lowest one, you may be discounting, and the discount's already built into the data. If you start at the highest one, one of the concerns, and you've all seen this, I'm sure, is it's always hard to back away from something. If you start high, chances are recommendations tend to stay there. So, at least the midpoint seems to be, fair. It could move in either direction based on factors. So if unless there's leaning, we'll go in the leaning direction. But if it's sort of a toss up, and you're okay, we'll just go with the middle, the sort of the median recommendation.
I guess the one caveat that I personally would like to get some more information on is when we're dealing with the drugs and the weights and how to handle those. I mean, I liked your comment about those three buckets, the users, the dealers supporting their habit versus sort of what I always refer to as the for-profit dealers.
Yeah.
But I'm interested to hear more about how we can address that in a manner that's reflective of, sort of the trends that the General Assembly has adopted over the years, sort of the lessening concern with marijuana, the increased concern with heroin, recognizing and appreciating those distinctions that have been driven out through different policies over the last probably 10 years or so.
Sure.
So I'd look for some more information in that regard.
Absolutely. We can pull that in. One of the things that's helpful is in some of our data, we separate out sort of the high level prior drug trafficking. I think it's 50 grams or more from the lower. So that's 1, 2, and 3 point categories, I think, in the prior record score. But we'll see what we can do, because that's a difficult area, but we'll at least get you lots of data on it.
And one other thing is with regard to juvenile adjudications and prior record score, where did we leave that at?
So at this point, we had, I think one of our grad students do some really helpful research on that. In fact, there was a whole group. I think we can share that with the group, give you some background on what we found. And then anything else?
Again, I think that work that we do. Look at all. Only look at half per point. Evolve that in these lapsing category. A lot of impact in that category. Memos.
And we'll follow up with the juvenile court judges, both on that report and any suggestions, recommendations that they may have, even if it's just staff discussions. But there may be an opportunity to meet with the JCJ, just as we're working.
Yeah. Thank you.
Did you want anybody to weigh in today on the lapsing for adult, the discussion
Sure.
that's brought in today?
We're open to
I mean, do
anything
you
you're
want
willing
us to say we want you to go forward with that? What's
Yeah.
everybody's position on that? It was, I think,
lapsing of both adult and juvenile. So the juvenile adjudication is the one thing. On the adult side, I think there were 2 categories that we had.
yeah.
So the adult on the lower category, so F3s and down, so F3, M1, F3s, a 10-year crime-free period. And one of the things we'd be looking at is there anything on the lower end of that, like M3s, where clean slate comes into play to take full advantage of that? And then the next category for F2s and F1s, including everything, was 15 years of crime-free. And one of the issues that we discussed before, and we'll have to discuss in the future with the commission, is how do you define crime-free? In some jurisdictions, you're not in custody because you get a 20 to 40-year sentence. Hopefully, you're crime-free when you're, but that's different than being on the street and being crime-free. So those are some of the definitions.
Mark, can you send out something? It seems to be quite a bit to that you
Sure,
said. So
absolutely. Yeah,
If
we
you could
we
send
will.
out something that we could look at.
Yeah,
and-
we'll capture all of this.
Yeah.
And get something else. We appreciate all the discussion. Yeah, yeah. We will not do. We saved a lot of paper initially, but
Quit printing stuff out. He's
Yeah,
gotten
yeah.
much better at electronics.
yeah, thank you. Yeah.
So
So, could I just make one quick
Yeah,
comment?
yeah, please.
I just wanted to follow up on a point that Rep. Stevens actually raised about the tailoring the way we treat the different drug offenses.
Yeah.
And I think just another consideration for our body is, in approaching it from the deterrence and public safety and legal accountability angle that we're approaching it, that, we're by nature not fully addressing what it takes to whether it's for users, for people who may be
Mhm.
dealing to supply their own habit, that in calling it a public health issue, that there are other arms outside of the sentencing commission that may have a responsibility
Mhm.
around addressing those different
Right.
tiers. And so just talking about it from a sentencing perspective, it's not going to be conclusive.
No, that makes sense. One of the things that that we did, in the last year or so was we partnered with Vital Strategies, Bloomberg Group, to look at particularly probation violations related to drug use, and so there may be some opportunities to revisit that and look more broadly at just drug use, not just for revocations of probation. That might be helpful. Well, first, thank you for all the time. I know this is a long day and a lot of material. We will try to package it together and summarize it for everyone, and we'll come up with a sort of a checklist that we'll get out to you in terms of what we'll be working on. If you have any suggestions or other additions to that, let us know, and then we'll give you a lot of gifts in September, I think. Thank you again. Appreciate it.
thanks, everybody.